Good afternoon and welcome to the Renaissance Society Forum Committee presentation today. Our speaker, Jamie Lau, clinical professor of law at Duke Law School, is the supervising attorney for Duke Law Wrongful Convictions Clinic, as well as faculty advisor to the school's Innocence Project. He is the 2021 recipient of the North Carolina Advocates for Justice Kellie Crabtree Award for his successful exoneration of a wrongly convicted client. He will address the difficulties exonerees face as their freedom begins, as well as the systemic flaws leading to wrongful convictions. The Forum Committee is honored to introduce Professor Jamie Lau.
Hello, Michelle, and thank you for having me. I'm excited to be here tonight. This is my second evening presentation this week. The first was at UNC, North Carolina. Being a Duke professor, I was welcomed with a good deal of hospitality at North Carolina this week. And if anybody knows a thing about college basketball this week, that was a relief for me. So I look forward to the same bit of hospitality being extended tonight. I want to begin by sharing my screen. I have a PowerPoint here. Hopefully everything will work out for us this evening. Try that one. It was optimized. So I am a clinical professor at Duke Law and the supervising attorney for our wrongful convictions client. And our wrongful convictions clinic represents people who are incarcerated in North Carolina for crimes occurring in North Carolina. So I should say not all our clients are incarcerated in North Carolina if they were convicted for a federal crime occurring in North Carolina, but because of the nature of the Federal Bureau of Prisons, are incarcerated somewhere outside of the state. We, at this point, our clinic has represented 10 men who have been exonerated after, over 100 years collectively of wrongful incarceration. It's actually over 200 years for the 10 men that we've represented have been wrongfully incarcerated by the state of North Carolina. Among those people who have been wrongfully incarcerated are a gentleman named Ronnie Long, and we'll talk a lot about his case today, who was wrongly imprisoned in North Carolina for 44 years. So he was incarcerated before I was even born, as well as a gentleman named Charles Ray Finch, who was wrongly incarcerated for 43 years. These men were exonerated after long legal fights. I have a quote at the top of this slide from Brian Stevenson, and it talks about how fear can make us blind, irrational, and dangerous. I believe a lot of these wrongful convictions are the product of some of that irrationality that can occur when someone's fearful because a crime occurred in a community. There are many causes of wrongful incarceration. There are mistaken identifications. A growing body of social science research speaks to just how bad we are at being able to recall the face of someone who may have caused us harm. Or even if we're just a witness and the person didn't cause us harm directly, there's a broad body of research discussing how difficult it is to make an accurate identification after a period of time following the occurrence of the crime. People falsely confess. Lots of people like to think, if someone's innocent, they would not falsely confess to a crime. But the nature of interrogation in this country is such that wrongful conviction or wrongful confessions happen, and they happen with some surprising regularity. Part of the reason that's the case is because of the ability of law enforcement officers during the course of an interrogation to lie to a suspect about the evidence that they have in their custody, which causes this process where the individual tries to explain away the evidence that they're being confronted with, leading potentially to a wrongful confession in a high stress circumstance. We teach a class at Duke, a seminar component to our clinic where students assist us with litigating these wrongful convictions cases. And in that class, we show a video of an individual who was a MP in the military. It was military police, and he was accused of raping a woman and interrogated. Presumably, he had knowledge of the tactics that would be used through the course of that interrogation. But while he was being interrogated, he was lied to multiple times about the evidence that had been collected. And within 2 hours, he had falsely confessed to raping this woman because of the high stress situation he was in and the lies that he was being fed. One caveat to that is he had been drinking the prior night, so everything wasn't working for him. He wasn't hitting on all cylinders the evening before, but he still had no role in this crime, and we know that because DNA testing that came out subsequent to his false confession indicated that the semen in the woman who had said she had been raped wasn't his. But he was told repeatedly that they had collected it and it was his. So false confessions occur, and they can even occur when somebody has knowledge of the tactics through the interrogation. There are all sorts of unreliable forensic sciences. Prior to DNA becoming widespread, microscopic hair comparison led to several now known wrongful convictions as a product of analysts testifying that suspect hair collected at a crime scene matched the hair of a person charged with the crime, that they were identical and from the same source, and DNA testing later on those hairs made it plain that they weren't from the same individual. So there's unreliable forensic science that comes into these criminal cases. There's prosecutorial and law enforcement misconduct where evidence is hid and not disclosed, or in the worst case scenarios, but not as frequently, is simply manufactured. Now, the Charles Ray Finch case, where you see Mr. Finch having served 43 years of wrongful incarcerated, being wheeled from prison on the day the judge vacated his conviction, that was a case where there was, just this intentional setup to pin the crime on Mr. Finch. Without going too deep into the case, Mr. Finch was charged with a homicide that occurred during the course of a robbery gone bad. He was ultimately convicted. We have records from federal investigators that the sheriff officer who arrested Mr. Finch, helped secure the evidence to convict Mr. Finch, was himself the leader of a theft ring where individuals would rob stores. And the evidence used to convict him was that the store owner had been shot with a shotgun. Ultimately, the investigation that was done post-conviction revealed that the person wasn't shot with a shotgun at all, but that fit the case against Mr. Finch, and that perhaps that deputy himself and his theft ring that he would later be charged and indicted for had some role in the events that occurred that night, and that Mr. Finch had just been arrested to deflect attention from the crimes that the officer himself was involved in during the period of time when Mr. Finch was convicted in the 1970s. It was 1976. So misconduct does occur. And then there are times when new evidence is discovered, undermining potentially a mistaken ID or other evidence in the case, revealing that, while there may have been circumstantial evidence pointing to the person who was charged and arrested, it was later uncovered that they were in fact innocent. To date, the National Registry of Exonerations shows that 3,045 people have been exonerated for crimes they didn't commit after serving periods in prison since 1989. And those individuals have collectively served 26,700 years in prison. In North Carolina, we have a figure that the Department of Corrections puts out, and the Department of Corrections puts out this figure that it costs about $30,000 a year on average to house a person in prison. To put that in perspective, the individuals on the National Registry, it would have cost taxpayers over $800 million to hold those people wrongfully in prison for those years. So there's a high cost to wrongful convictions from a monetary standpoint, without getting into the ripple effect it has on trust between the community and the people sworn to keep those communities safe. And that monetary cost doesn't even factor in all the fees for lawyers and litigating for these cases that transpire. Now, I'm going to start talking about the Ronnie Long case really beginning at the end, because having identified some of those sources of wrongful convictions, most people believe that I spend all my time litigating and arguing convictions in a particular case. Unfortunately, that's not the case. I spend the vast majority of my time arguing that a case should be heard before a court, and that we shouldn't dismiss the case solely on a procedural basis, that it's taking so long to uncover the evidence that demonstrates the error in the conviction. Procedural mechanisms are typically used by the state or the government to try and keep these cases from ever being heard after a person is convicted. The court system in criminal procedure puts a high value on finality in cases. So there is a high bar erected to permitting us to even pursue litigation in post-conviction circumstances that would demonstrate the innocence of our clients. So I want to start by playing an audio clip from an oral argument that took place in the Fourth Circuit Court of Appeals. The Fourth Circuit is just below the Supreme Court with respect to the federal court system. And this argument occurred in May of 2020, and it had to do with Ronnie Long's case, the individual you saw in the slide before, who had been wrongly incarcerated for 44 years. On this slide, you'll see a photo from a protest that occurred in 1976 at the time he was arrested, calling into question the strength of the state's case against him, and arguing at that time that he had been more or less set up by law enforcement officers during a period of real racial unrest in the South. It was after Brown versus Board of Education. The South was being forced to integrate, and there was a lot of resistance to that integration. I've always described the Ronnie Long case as a real vestige of the embarrassing racial past of the South, because he was incarcerated during a period of time where, as you'll hear from Judge Wynn, racial hostilities were at an all-time high. We litigated this case, and our primary efforts throughout was to get the court to consider the case on its merits and to consider the evidence in the case demonstrating his innocence. And the audio clip I'm going to play is approximately 6 to 7 minutes long, but it's Judge Wynn making a statement to the attorney for the North Carolina Attorney General's office, who was arguing that Mr. Long's case should be declined because he failed to present evidence sufficient to overcome the procedural bars in place to obtaining relief in the federal courts. So I'm going to play this clip of Judge Wynn and then talk some about Mr. Long's case and the litigation in his case.
You put that all together.
Judge Wynn has a question. I just wanted to follow up somewhat on Judge Mott's question and the answers that you give in terms of the evidence. You've indicated on several occasions, particularly with regard to the detective, you didn't say it was false or dishonest. You said, well, he was mistaken or inaccurate. When the prosecutor argued at the end, you didn't say, oh, that was not right, it was inaccurate. And I wonder, in light of Judge Mott's question, which I think goes deeper than just the practice, the procedural practice of what happened in court. We're talking about the realities of circumstance 44 years ago in North Carolina, in Concord, North Carolina, which I've lived all my life. We're talking about the reality of many types of prosecutions and circumstances in which law enforcement did certain things that were certainly not, they were a little bit more inaccurate. They were deliberate in what they were doing. And here, the zeal to prosecute 44 years ago with evidence that clearly, even then, should have been disclosed. And the question then becomes up as to materiality. Well, we've got so much other stuff here. Maybe then we're going to excuse this sort of conduct. And I understand that we cannot put ourselves back in 1976, in 2020. But the reality is when we apply 2020 arguments to evaluate what happened with a jury in 1976 under these circumstances, we go back to Judge Motz's question of how do we view 1976 and the realities that we are not being so forthwith in discussing here today, because we just don't discuss things like there were black men who were being prosecuted wrongfully, and we know in great numbers. There had been lynchings far beyond then, and it was not over in 1976. It was continual. And yet you have evidence here that prosecutors had evidence that clearly any defense counsel in the world, not only in 1976, but since the history of this country, would have wanted or needed and should have been supplied, as later indicated by Brady. And yet they did not provide it. And then to get on the stand and make statements that are patently false, characterize them as inaccurate as you want, they were just patently false statements, coupled with as you say, the totality of the circumstances in dealing with that era. That's the element of concern we're talking about when we say 44 years ago. And then I'll end with one last thing. When we look at these cases, I often wonder, why is there such zeal not to look at evidence and make that determination now? What is it about us that want to prosecute and keep people in jail when we know evidence may exist that might lead to a different conclusion? Why is that so offensive to us now that we want to go and protect activity that happened 44 years ago? And it may come out to the same result. But what is the harm? And in the end result, he spent 44 years in jail, even if he was to get out. That's a significant punishment. So when we look at these circumstances, I just don't understand why we wouldn't take a look at it. And what is the problem with having more discovery? And particularly when we know, like the fingerprint information here, as you say, that is latent evidence that ought to be considered. We didn't have, and by the way, I think there was some semen. Somehow it disappeared. Did it not? I don't know if it ever came up, but there's evidence it was in the police's custody. The semen, which you didn't have DNA back then, but you surely did have tests that could have led to an exoneration if certain tests from that had indicated such, or at least strong evidence that he did not do it. And yet it disappears. But we in 2020, we sit here with our own pre-notions of how evidence should be viewed, and we said, well, we're going to just give it the benefit of the doubt in 2020. But we know what happened in 1976. It's very difficult for the conscience to even accept that as an argument when it's so simple. All we're saying is just look at the evidence. No one's making a determination today. Just look at it. What's the problem with that?
I don't have a problem with that, and I'd like to explain. I mean, there's a lot of things that Your Honor just said that I would like to address and agree with. Frankly, almost all of it. This case, I said at the beginning, it does deserve a hard look. Our system decides that hard look should primarily occur in state court, and it did occur in state court. The MER hearing in this case, we talk about it as a hearing. It was essentially a bench trial. It was 3 days long. I think the transcript may be longer than the trial transcript. The Judge Spainhour, he took extraordinary efforts to make sure that the defense was able to access evidence that they thought might be available, and there were searches done, and there were searches of storage units, and there were dozens and dozens of man hours spent searching records and finding things, and all of that is exactly right. And I agree with you. I don't want to get that narrow point away from the broader point that I am aware of that context. I was not alive during this time period, but I am aware of it, and I don't want the court to think that we haven't forgotten it.
Well, I'm going to just, because we could go on, and I do appreciate your candor in acknowledging that, what I said was essentially true and remains true. The problem is we use procedural rules and we use our own court-made rules to what Chief Judge Gregory alluded to, avoid justice. When did justice leave the court? So that every time we get a chance, we can figure out some legal maneuver to not address what every person in the heart has some sort of feeling, oh, something went amiss back then. But we have some rules that will let us just do away with this and just keep him in jail. What's the harm? It's going on, and we're going on with our lives. That's the question. When did justice leave the process such that we let our
put that all together?
Judge Wynn has a question.
I stopped it a bit short, but Judge Wynn wraps up asking, when did justice leave the courtroom? And in the Ronnie Long case, I would submit to you there was never any justice, intended in the courtroom. It was 1976 in the South. He was tried by an all-white jury. He was tried by an all-white jury by design. The jury commission chair at the time had a list of potential jurors, and before jurors' summons were sent to potential jurors to arrive at the courthouse for jury selection, the jury chairperson brought that list of potential jurors to the local sheriff, to the chief of police. There's testimony that the chief of police and some of his deputies, the very people investigating the case against Mr. Long, sat with a red pen and crossed out people they deemed undesirable or unfit for jury service. So the resulting pool of jurors that showed up at the courthouse was predominantly white. There were only 4 black jurors that ended up receiving summons, and they were all dismissed and not sat on Mr. Long's jury. Other issues with the case, but what Judge Wynn is talking about was the problem that I spoke to. This use of procedure to prevent us from litigating and highlighting the innocence of our clients, and the state's attempt here to use procedure. Now, lest you think, well, this was 1976, how long should people have an opportunity to come back and look at the evidence, and look at a given case? The answer to me is once the state finally comes clean with all the material and information it has. And in this case, that didn't occur until more than 30 years after Mr. Long had been convicted. He was convicted in 1976 by an all-white jury, and the only evidence against him was the victim taking the stand and saying it was Mr. Long who assaulted me. At the time, it wasn't known that during the course of the investigation, law enforcement collected all sorts of items of evidence from the home where the woman was assaulted, including fingerprints, suspect hair, semen, as you heard Judge Wynn allude to, and all these items were collected, and much of it was subjected to forensic tests, and Long had always maintained his innocence, and those forensic tests were never revealed. They were never provided to Mr. Long's attorneys, and those forensics tests excluded him at every point. None of the fingerprints matched him. The suspect hair collected from the scene was deemed to not be a match. So he was arrested, convicted in 1976, and he began an effort that ended up being a 44-year odyssey to demonstrate his innocence. And you see here in 1986, pro se motion, pro se habeas petition. These are all things he's filing on his own without the benefit of a counsel. Because the other point I want to make is that you're not entitled to have an attorney once you're convicted and once the direct appeal is decided. In post-conviction, if it's not a capital case, if somebody's not on death row, there's no entitlement to counsel. So Mr. Long initially was fighting for his freedom on his own and trying to get courts to care. The forensic test results were hidden throughout that effort and throughout that fight. So you see here all these years of him trying to demonstrate his innocence. That goes all the way to 2005. And then sometime between this period of 2005 and 2008, it's first discovered that they had done all this forensic testing in his case, and all the forensic testing had excluded Mr. Long as the possible person who was in the home that night. The state argued none of it made a difference because she had identified or positively identified Mr. Long as her attacker. Given that, no amount of evidence would ever demonstrate his innocence. And the problem with that identification is it occurred 13 days after the crime. The woman who made the identification was dressed in a disguise, brought to a courthouse, asked to sit in the courtroom and see if there was anybody there who she could identify as the person who assaulted her. Mr. Long was in the courtroom appearing for trespassing charge in the local park. He was there after curfew. She testified there were only 12 black males. Mr. Long in the courtroom, Mr. Long was the only one who looked remotely similar to the person who attacked her. And she also sat there in Mr. Long's presence for an hour and a half before identifying him. Now imagine being in a situation where you're so scared and terrified, and she testified to her fear at that time, that you're wearing a disguise and you're there for an hour and a half. The only way in which that experience could end was for her to identify someone. And through the statements that she made, it's clear why she identified Mr. Long. He was the only person that looked remotely similar in her eyes to the person who had attacked her 13 days later, or 13 days earlier. That was the evidence that the state was trying to hang its hat on, despite every bit of forensic evidence excluding him that was collected from the scene, and the utter disappearance of probably the most probative evidence of who was involved, the semen collected in the case. So all this litigation keeps transpiring, and all the way through August 2012, he is being denied at every turn, and many of the denials he's receiving are on the basis of the fact that it's been so long that the courts don't believe that he should have the opportunity to litigate his case. And then my office got involved after August 2012 when his petitions to the federal court was denied as successive. Remember, back in 1988 or 1989, Mr. Long had filed a petition on his own. So the later effort in federal court was denied because it was his second time. And under the rules, you're only allowed to file a single action in federal court seeking relief unless you meet a very high threshold to come back and seek relief from the federal court. So when we first got involved, our entire issue was getting him back into federal court. We had to figure out a way to get the courts to consider all the evidence demonstrating his innocence. And we did that by filing this motion to the Fourth Circuit Court of Appeals, asking them to permit us to go back and litigate Mr. Long's case. The motion was filed, and we attached, it's not popping up, the other thing that's supposed to pop up, but it shows the attachments. We attached materials highlighting the new evidence that we would present in the federal courts, demonstrating Mr. Long's innocence. We were granted permission, and we filed a petition seeking a writ of habeas corpus from the federal courts, vacating Mr. Long's conviction, finding that the state of North Carolina had violated his constitutional rights at the time of trial. We still had procedural barriers. One of the things we had to establish was that his actual innocence was sufficiently proven by the materials that we submitted that he should be entitled to review of the case. That's a really high bar. The bar we faced, we had to show that the evidence that was in the record clear and convincingly established Mr. Long's innocence before we could even move to the constitutional violations that occurred at his trial. The suppression of that favorable evidence that demonstrated that he was not in the home, he was not involved in any way, shape, or form in the crime. So that was the initial procedural threshold we had to get over before we could even start litigating the merits of our claims of the constitutional violations that resulted in his conviction. At that time, it wasn't 44 years, but about 41 years earlier. So what was some of the evidence that was withheld? I told you there was a forensic report. These are the notes from that forensic report talking about the suspect hair that was collected from the scene. And in the records, that suspect hair, and this was a white woman, there's testimony that she didn't let blacks into her home. Her exact words was, "They don't invite me into their house. I don't invite blacks into my house." Now, Mr. Long, a black male, they collected hairs from her home, and the analyst looked at those hairs, and his conclusion that those hairs were of the parlance of the lab is of Negroid or Mongolian descent. So they identified those hairs as coming either from a black person or a person from an Asian ancestry. And when he looked at those hairs and compared them to Mr. Long's hair, he said they're different. Mr. Long, these are not the source of the suspect hairs at the scene. And then this report was never turned over. It was also never discussed in some of the prior post-conviction hearings until it was kind of lucked upon by the attorneys who were representing him back at that time. There's another problem was the officers, to prevent Mr. Long and his defense team from finding these reports describing all the evidence collected in the case and how Mr. Long wasn't included in the evidence in the case. Officers lied about bringing evidence to the lab. And this next slide is an example of some of the lies that were being told at trial. When Mr. Long was arrested, he was wearing a black leather jacket. He was arrested over 13 days later, about 2 weeks after the assault occurred, after the identification I described in the courtroom, and he was wearing the black leather jacket. They took the black leather jacket, they sent it to the lab, and the reason they sent it to the lab was because when the victim in this case was brought to the hospital, she described to the doctors a very significant physical fight that she was having to prevent it from being assaulted that included her nails being ripped back off of her fingers because she was scratching and clawing so hard at the person who was attacking her, including on his jacket. So they brought the jacket to the lab to try and review it to determine whether or not there was any indications on the jacket that it had been involved in this, what was described as a violent struggle. And they didn't identify any unusual markings or anything unusual with the jacket. It was in relatively good shape, nothing indicating that it had been worn during the course of this violent struggle. So during the course of trial, the jacket comes up, and the attorney for Mr. Long asked about the jacket being collected, where did it go? And he testifies he's had it the whole time since it was collected. There was never any test done on it. And he does that with all the forensic evidence in the case. He identifies, the evidence and talks about, how he kept it in his custody and it didn't go anywhere after that. When in fact it went to a lab and they received results indicating that Mr. Long himself wasn't indicated by any of the evidence collected. So we argue in the Fourth Circuit that collectively all the evidence not only establishes his innocence, but it clear and convincingly establishes his innocence, and that on the basis of that, he should be afforded an opportunity to have all his constitutional claims considered and for relief to be granted and his conviction to be vacated. So we had to overcome these very high procedural barriers. Fortunately, we were able to overcome the barriers, and the judge in the case eventually adjudicated that his constitutional rights were violated, sent it back. It says for consideration of his actual innocence question. It kind of took a wonky procedural path to the Fourth Circuit, but the end of the day what they were trying to determine is whether or not they were going to consider the merits and then whether he could afford relief because of meeting this high standard. So it was remanded back, and the district court ultimately entered the order saying we had demonstrated actual innocence, and in light of that, his conviction should be vacated. One of the things that's most devastating about this case is that we know that law enforcement officers took the stand or to tell the truth and then proceeded to lie. We know that forensic evidence was collected in the case, that it was brought to the state forensic lab. The state forensic lab evaluated that evidence, and ultimately the state forensic lab sent reports back to the same law enforcement officers who lied at trial, indicated that none of the evidence collected connected Mr. Long to the assault. And then on the basis of those two things, the prosecutor argued at trial that Mr. Long was the person who had assaulted the victim in the case, and that the law enforcement officers, to believe Mr. Long was innocent, you'd have to believe that the law enforcement officers were engaged in untruthful conduct, and the defense team was accused of trying to sully the reputations of these upstanding law enforcement officers. Judge Wynn, the very judge you heard at the beginning, coming back to Judge Wynn, wrote an opinion, a concurring opinion, that Mr. Long should be entitled to relief, determining through his evaluation of all the evidence that Mr. Long had met that standard of clear and convincing evidence that he was actually innocent. But the thing about Mr. Long and the lies that were being told at the time is North Carolina had a mandatory death sentence. If he was convicted when he was arrested and officers engaged in this conduct of hiding evidence, he would have been put to death by today, but for the fact in July of 1976, the Supreme Court of the United States decided this case, Woodson versus North Carolina, finding that North Carolina's mandatory capital punishment scheme was unconstitutional. The only reason Mr. Long lived long enough to be ultimately vindicated and prove all those people who were protesting that slide back in 1976 prove true what they were saying all along, that he had been set up to take the fall for this crime, was the fact that this Woodson decision by the United States Supreme Court occurred that resulted him receiving a life sentence without the possibility of parole, as opposed to be sentenced to death. And then we were able to take on the case. Otherwise, he would have been killed long ago by the state. So Judge Wynn wrote this statement in his opinion saying, nor can we ignore the devastating fact that the officers suppressed evidence that they knew tended to show Mr. Long's innocence, even though Mr. Long was charged with first-degree rape at a time when that crime carried a mandatory death sentence in North Carolina. That is, the officers hid evidence despite knowing that doing so could lead directly to Mr. Long's death. Such an action is repugnant in any context, but it takes on particular sinister meaning here, given our country's historic treatment of Black men accused of raping white women. Ronnie, if you were to talk to him, Mr. Long would tell you that there was God's hand was at work in the Woodson decision, sparing his life, so he could ultimately be free and vindicated 44 years later. We were very grateful that that's the case, and ultimately, after the Fourth Circuit's decision, approximately 3 days later, on the birthday of his wife, Mr. Long, who he met while he was incarcerated, Mr. Long conviction was vacated, and the next day, all of the charges were dismissed and he was fully exonerated. And I just have a very brief clip I want to show of Mr. Long leaving prison that day, if technology works out.
Elated, yeah. Elated. I'm telling you, it's been a long road, but yeah, it's over with. It's over with now. I appreciate the support. I appreciate the people that come out and supported me. And I wanted you to know, you understand, saying, look, if they will never, ever never, ever, ever lock me up again. That's right. Never lock me up again. Yeah.
When I talked to you earlier this afternoon, you were still in disbelief. How are you feeling?
It's over. It's real. This is real. See, this is real. See, that's over there. I left that over there. This is real right here. Yeah. For real. Hey, look, and I'm gonna try to enjoy every minute of it. Every minute I can enjoy. What little time I got left in my life, I'm gonna try to enjoy that.
What are you looking forward to doing first?
What I'm looking forward to doing? Getting affiliated with those, you understand, what I wouldn't affiliate with when I got locked up. I got nieces and nephews out here, you understand, that they don't even know me. Then I got to go see my nieces and nephews, my great nieces and nephews.
And a grandbaby on the way.
And a grandbaby, yeah.
What's your first meal?
My
Free man.
Hey, look. Look. Macaroni and cheese. Beef ribs.
Beef ribs.
Yeah. A salad.
Yes.
And some lemonade.
And lemonade.
So we really disappointed Mr. Long because we didn't get him that first meal because the restaurant we ultimately ended up at, he hadn't told us previously what he wanted to have, and the restaurant didn't have beef ribs, macaroni and cheese, and exactly what he wanted. But Mr. Long's case sort of highlights what I just wanted to, what I was hoping would come across. There are all these reasons why men and women are wrongly incarcerated. But one of the biggest barriers to our efforts to exonerate are these barriers erected by arguments based on procedure that we shouldn't be afforded the opportunity to go into court and fight for these men, even when there's new evidence, even when there's evidence that materials have been suppressed. I mean, the state in this case was arguing, yeah, that happened. They wouldn't concede that the officers lied. They just testified inaccurately, maybe made a mistake. But you don't need to look at it. It's been so long. And there's a decision that really takes the state to task for arguing about the length of time, given the fact that all this evidence remained concealed over the course of much of this period of time. So now, with that, I just want to briefly, introduce some of the clients that we have helped. Sean Massey was wrongfully incarcerated for 11 years before he was ultimately exonerated. Lamont Armstrong, 17 years. Howard Dudley, 24 years. Charles Ray Finch, who was in one of the original slides, 43 years. Here's Ronnie after purchasing a home once he was free, 44 years. Will Shaw, 6 years. Dante Sharp, 25 years. We have 3 other clients, but I one of them was a Mexican heritage and 2 are white, but I chose these 7 to highlight one other aspect. I mean, there is a racial component to wrongful convictions. Black people are 7 times more likely to be wrongfully convicted for murder based on a study that was undertaken by the National Registry of Exonerations, 3.5 times more likely to be wrongfully convicted for sexual assault, rape, and 12 times more likely to be wrongfully convicted for drug-related crimes. So our system is very good at disproportionately wrongfully incarcerating people of color, but that's probably a sort of systemic design because the numbers will tell us that the system is also very good at targeting communities of color with respect to policing, leading to their disproportionate incarceration more generally. I'm happy to answer any questions that you guys may have, and thank you for your attention.
Thank you, Jamie. What an incredibly robust background to this story specifically, as well as other stories that we hear about on a regular basis. You answered a lot of questions and you also generated a lot of questions. So we'll see if we can get through some of these here. One of the first ones, some of these are specifically about Ronnie Long, and then some are just generic about the process and systems. Let's see, where was that one that I liked? Did Long's attorney not know there was evidence collected? Could his attorney not ask for the evidence as a reason for appeal?
His attorney did not know what evidence was collected from the crime scene itself. His attorney suspected, because of the nature of these investigations in North Carolina at the time, that a sexual assault kit had been collected at the hospital. Colloquially, a rape kit had been collected with semen and other items. The attorney specifically asked the district attorney whether or not that kit had been collected, and was told that it was not collected in this instance. So they did ask and was told explicitly that it wasn't collected. At the time, there wasn't DNA testing that could be done with regards to the evidence collected, but ABO blood typing was available. So he could have been excluded as the source of the semen that was collected back in '76, conclusively establishing that he was not the person. But the prosecutor's office directly told counsel that none was collected.
You may have answered this already, but were there any charges placed against those specific officers who lied and or hid evidence?
No, I would love for that to be the case. It rarely happens in these cases that anybody is held accountable for their conduct. The primary officer who was doing the lying, the evidence custodian from the Concord Police Department, very shortly after this case, a matter of years, had left the department and then was arrested and indicted on federal charges for mail fraud and larceny, and did serve time himself, incarcerated in the federal system because he was stealing checks out of mailboxes and cash out of mailboxes, in the Charlotte area. So
Does
he's
Mr.
not
Long,
a person.
okay. Does Mr. Long expect to get any kind of financial compensation, or has he, for the time he was incarcerated?
So in North Carolina, financial compensation is available if you receive a pardon of innocence from the governor. So if our governor formally recognizes that the case against you failed to establish your guilt and you're innocent, then you can be awarded compensation. In Mr. Long's case, he was exonerated in August of 2020. In December of 2020, the governor took that step and granted him a pardon of innocence, acknowledging his full innocence in the case. That triggered compensation of $750,000, which is what was used to purchase that home in the picture that you saw. Of course, $750,000 for 44 years of your life, it comes out to, I think, $17,000 a year as compensation for missed birthdays, missed weddings, missed funerals. I mean, his mother and dad passed away while he was incarcerated. And very, very sadly, he was exonerated and freed in August of 2020. His mother passed away in July of 2020. So she had passed away just 1 month prior to him achieving his freedom.
Mm. A couple of questions about DNA that are kind of similar. Is DNA largely the factor for exoneration, and how accurate is it now?
Well, many cases are non-DNA tested cases where there's exonerations, and typically those are the product of like this misconduct where evidence that establishes that an individual was innocent has been suppressed. I have a friend, Ricky Kidd, who was an exoneree in Missouri. They actually suppressed the fact that he was at a sheriff's office in another town applying for a concealed carry permit as the crime was being committed. And ultimately, once that came out, he was exonerated once it was established that he was in another law enforcement office when he was accused and wrongfully convicted for a crime in another part of Missouri. So not always DNA. Now, DNA and its accuracy, DNA is really the gold standard if you're talking about a case like Ronnie Long, right? Sexual assault with a unknown stranger perpetrator that leaves semen behind. However, DNA in cases like homicide and other types of cases can get really muddy quick because mixtures of DNA profiles. Like if you try and, for example, a theft case, right? If you try and somebody turns a doorknob and walks into a home and takes things from the home, if you tried to get DNA from that doorknob, you might get the DNA of 7, 8 different people mixed together because it's a common source that people are touching. So DNA is pretty good in certain cases, but when you start getting into complex DNA mixtures, its ability to provide accurately or to identify accurately profiles of people who were the perpetrators of crime diminishes significantly.
Makes sense. Is there any movement to forbid or even curtail manipulation by false claims from the police or suspects?
What may need a bit more on that one.
Asking if there's anything in the works to start to hinder any false claims that are made by the police or suspects.
So some of the lying that occurs by law enforcement just as a product of interrogation, is that recently that was outlawed. I believe it was New York was the state recently passed an act outlining police lying during the course of interrogations about the evidence that they have to try and secure false confessions from people, because it's just manipulating to try and get them to say something that's incriminating. With respect to curtailing some of the other kind of really unreliable testimony that occurs in North Carolina for some time, there is very often testimony in criminal cases. It happens with such regularity that we don't even think about it all that much, where a person that's charged with a crime will take the stand and testify that this person told me about the crime he committed while we were incarcerated together or while we were out on the street, and that will be used as evidence against a criminal defendant, but it's all being done so that person can gain favor in his own criminal case, which really diminishes any credibility, but it's offered a lot. North Carolina, we've tried to, over the course of I have a colleague who runs a nonprofit here in Durham, North Carolina, has been pushing to get a jailhouse informant or a snitch bill passed that would require a hearing on whether or not that person's testimony is even credible enough to go before a jury. So it would be inadmissible unless there was some corroborating element that law enforcement can find to establish its veracity. So that's an effort that has been ongoing in North Carolina, but great resistance by district attorneys who scream about the resources it would take to hold these separate hearings to determine the reliability has held it up.
Does suppression of evidence occur in cases that your wrongful death projects, are able to intervene in?
It's fairly common in the older cases that we handle. Now in North Carolina, we have a history of gamesmanship that was really occurring between prosecutors' offices and defendants that resulted in a change in the law in 2004 when it was found that evidence was suppressed in some high-profile death sentence cases here in the state. In 2004, the law was changed that made open file discovery the standard in North Carolina criminal cases. So here in North Carolina, a criminal defendant is now entitled to every document, every note, handwritten or otherwise, that's collected through the course of an investigation. So I think a lot of that gamesmanship has subsided with respect to cases since 2004, although there are some pretty high profile examples where, something didn't get turned over that should have, even with the changes in the law. But before 2004, we find it fairly common that there was material that would have been beneficial to the defendant that was suppressed and not turned over because we didn't have open file discovery. And what prosecutors were required to turn over was very limited. Now they were supposed to under Brady, which is the Supreme Court decision saying that defendants are entitled as a part of due process to any evidence collected that's favorable to them. They're supposed to have turned it over. But the problem is that prosecutors were the gatekeeper of what was favorable, what was helpful, and what should be turned over. So they had a lot of leeway in holding stuff back before the law change in 2004, and were caught, holding stuff back that really should have been turned over, and in fact, helped conclusively prove innocence in some cases before that law changed. And this is still the standard in federal criminal cases. Some federal district courts have standing orders requiring the sharing of information from the prosecutors related to the government's investigation. But there are some high-profile cases where materials that were favorable was suppressed. Senator Ted Stevens being the most high-profile example, where there was a prosecution on the basis of some contractor work on his home in Alaska, and receiving that work at a discounted rate to take advantage of his political office, where it was subsequently learned that that wasn't in fact the case at all, and they had emails that were more revealing of what the fair value was, et cetera, that they just didn't turn over. And that conviction was ultimately vacated, but he lost an election and was no longer a senator from Alaska after that time. So it occurs with probably more regularity than we would ordinarily think.
And the last question we have time for is, was the real rapist ever found in Ronnie Long's case?
That's an interesting question. We're still on the search for that person. Incidentally, we know that there is a file of alternate suspects that has yet to be turned over to Mr. Long or anybody that's a representative of Mr. Long. There is an effort ongoing in federal courts through the course of civil litigation that's going on in that case to wrest that file away from the government, and we're hoping that that file sheds some light on the likely suspect and the person who actually committed the crime. It's beyond explanation why it hasn't been turned over yet, other than the fact that there's been so much deceit and dishonesty in the case. It just seems a continuation of that pattern.
Sadly, it does. Thank you so much, Professor, for your time today and the work that your organization does as well, too. I'm going to toss it back to Michelle.
Okay. Just wanted to thank Professor Lau for his thought-provoking presentation and the shocking layers of inequity that Ronnie Law endured. It's wonderful that there are people out there like you working for the wrongfully committed. In appreciation of your presentation, we are going to give you an honorary membership in the Renaissance Society and a monetary donation in your name to the Seth Nelson Student Emergency Grant Fund. Thank you for spending your time. It's been really a wonderful presentation and we learned a lot. All foreign presentations are recorded and archived. To see any of them, go to the Renaissance Society website homepage and click on recordings, and they will be available on YouTube under the Renaissance Society Forum Committee in a couple of days. Remember, the food pantry is there for students who are unable to have funds to get food for the Sacramento State University students. You can consider donating on the first forum of every month. Next week, we have a very important and interesting having to do with what to do as we age and our relatives age. Casey Sakahara and Lynn Humphreys will explain the variety of senior living and in-home care operations, covering the differences in the cost and level of care. They will discuss how vital it is to protect yourself when you or a loved one are searching for care or are faced with a crisis and need to find care immediately. The presentation will address how to avoid pitfalls in determining the best senior care. Please do join us next week for this important presentation.